We have sufficient comments present. Order, we're back in session. Mr. Bartlett, will you continue your answer if you can remember where we left off?
Yeah, it was simply to stress, I think, that new forms of communication, in particular social media, have meant that RIPA, in my view, in many ways, doesn't cover adequately for neither public reassurance nor creating an environment in which agencies feel confident to act.
So, from both angles, both from that of the security and intelligence agencies, but also from the angle of those motivated to consider the civil liberties aspect of these matters, or the parameters, I should more accurately say, of the authorities' actions in the collation of communications data, there's a need for a new legislative measure. Would you agree?
I absolutely would agree. In fact, I think that the draft bill doesn't cover anywhere near enough the new requirements that law enforcement agencies need in this new environment.
And it's in the interests of all sides that there be set out proper parameters under which the authorities can act and under which those who wish to monitor the authorities know the parameters that exist.
Precisely. I think that the problem here is how you maintain the association between, not two, but actually three different classes of public goods. So obviously the maintenance of national security and public order, citizens' right to law and to liberty and to privacy, but also the economic and social well-being of the nation, which is vital when considering how you would go about intruding on people's privacy in this space. The problem, of course, is how you do that in a period where people's views on privacy in this new area are not in any way settled. They differ vastly across different sectors of segments of the public. Necessarily, security threats are changing and are not always well known, and the technology required to do this is often unclear in the way that it would actually work and some of the ramifications that would have, not just next year, but in 10 years' time. Because if RIPA was out of date 5 years after it was passed, the speed of change with the capabilities of monitoring technology now is such that any bill passed now is likely to be, required to be reviewed within 2 or 3 years. So this is the great difficulty, and this is why I think that a much broader conversation about the nature of intelligence work on the internet more generally is required, beyond just comms data.
But for the moment, with this bill the subject of this scrutiny committee, what you've said is clear that the current law is inadequate and going forward is likely to be more and more inadequate. There therefore needs to be a new measure. Do you consider that this draft bill, which I'm presuming you've studied, you've indicated that it doesn't go far enough, I think, in your view, but do you think it would nevertheless better equip the security and intelligence services for the essential work that they have to do?
I have no reason to doubt when the Home Office and the Home Secretary want to put this measure into place, that it would facilitate law enforcement agencies to do their job. I actually think most of the people that I speak to about this would probably rather they didn't have to introduce such an expensive, obviously controversial measure. The problem, I think, is that RIPA and the other regulations are there also to reassure the public. And in that sense, I'm not convinced, partly a combination of good advocacy work and poor journalism, the way that this bill has been reported, I don't think it commands public neither understanding nor agreement in any meaningful way. And I think this is really important because it has been described consistently as a snooper's charter. Actually, a snooper's charter is about the ability for fishing expeditions, which are widely possible now outside of RIPA, through going onto open source social media sites and monitoring huge volumes of data about people. This is, I believe, the perception that people have about what this bill is essentially about. So and that's not what it's about, but this is why I think it needs to be widened so that that type of monitoring is actually regulated and brought under some kind of legal footing.
So it's actually diametrically opposite from those who call it a snooper's charter, in your view, because what this bill would do would help regulate where at the moment there is no regulation.
In some senses, yes, although, as I said, there's a huge area that isn't regulated under this, in my view, under this bill.
Can I look with you at the present law as it stands, and a couple of issues that there are about the present law? The position of Her Majesty's Government is that the present law does not require communication service providers to either generate or retain comms data for which they have no need already. Now, at the moment, they may have need for certain bits of data, usually for billing purposes, so they can bill people the right amount of money. But it doesn't require them to collate that data or retain it, and it doesn't apply to providers based overseas. So do you think that those issues need to be addressed? It's necessary for those issues to be addressed to allow the security and intelligence services and law enforcement generally to perform their functions properly?
I think part of the problem is there's not been, to my mind, quite enough evidence to demonstrate the necessity of this, particularly through case studies and examples that allow the members of the public to understand the relative trade-offs in this bill. I do believe that it probably is necessary. I think it's worth mentioning, I don't want to go into this particular question too much, because I think other evidence you've received is far more accurate and more knowledgeable than I'm able to provide you with. But many major organisations, of course, already do keep huge amounts of information on us. It might not be exactly in the way that security services want it, but a lot of it is available because it is, after all, data is now considered to be the raw material of the 21st century.
We've heard about supermarkets. And
well, of course. Facebook has hundreds of thousands of pieces of information on most of its users. However, in respect of the second point, the international jurisdiction...
Oh, I'm sorry, I've got to halt you again. There's another vote in the Commons.
I'm so sorry, Mr.
Or
Bartlett.
we're suspended until our quorum is back. Sorry about that. Yeah. In order, we are back in session. If you could continue, Mr. Bartlett, you were answering a question from Mr. Ellis.
I think I was going to say I can't answer this question particularly well, and I don't want to just gas off where I don't have special knowledge. But I think that the international point is a much broader one than you're probably going to be able to answer with this bill. The jurisdiction of the internet, or who has jurisdiction over it, is of course far broader an issue. Yeah,
I think, Mr. Bartlett, you've already answered in many ways, in that you've indicated in your initial responses that you think that there is a gap in the law at the moment. I don't want to mischaracterise you, so please correct me if I'm wrong. But there's a gap in the law at the moment that needs to be addressed, both in the interests of law enforcement, but also in the interests of those seeking to oversee what law enforcement does. Is that fair?
That's absolutely correct. Our national security strategy says that security intelligence work is predicated on public consent and understanding, and that's absolutely critical, that we need to understand and give some kind of consent, expressed through Parliament, of course, ultimately, to the measures that are taken to keep us safe. And I think that's why there does need to be an extension of surveillance and interception technology.
And if anything, you think this bill may not go far enough?
Correct.
Thank you. Mr. Bartlett, if I could pick you up on that point, I'm slightly confused.
Yeah.
You've just confirmed you'd like to see the bill go further and be wider, but I think earlier on in your evidence you said that part of the public concern is the bill seems to be far too wide. So can you clarify it for me?
Yeah, of course. In my view, and perhaps it is a little controversial, the bill is an extension of existing powers. Ultimately, we have regulated surveillance and interception in this country, of course. As it stands, there just isn't the data that some companies collect is not available to law enforcement agencies across the board, and this is an attempt to make sure that information is available. And actually regulate it, for example, accessing or putting a bug into somebody's personal living space, I consider to be far more intrusive, and we regulate that. The problem, I think, is that even though this has been, in my view, an extension of existing powers, it's widely understood now to be a complete radical shake-up of the way the intelligence and security apparatus work. So it's essentially allowing the government to snoop on everybody's emails, their social media presence, their web browser history, and everything else they do online. Now, actually, given that that is now the case, I think that that's the case, that's how the public in general and how it's been presented believe this law to be about. I think it's actually a good opportunity to regulate that very type of cyber snooping, which indeed is the ability of agencies, not just law enforcement agencies, but any public agency or private company or individual like me, to go around and collect huge volumes of data on people from open source methods. So I believe this is actually an opportunity to reassure the public about the broader way in which intelligence is collected from social media. And I think the reason it's an opportunity is because that is now how it's being understood, which I think is actually inaccurate.
So, on the one hand, you're saying, yes, the security services need these additional powers, but we should therefore put more regulations in the bill controlling surveillance, etc., and stronger governance measures. Is that
correct?
What you're saying? Okay.
Correct.
Thank you. Lord Strasbourg.
I take your point about the proposed bill being an extension of the existing powers, and can I perhaps explain your puzzlement at the public reaction in this way? Is it possible that the public are actually ignorant and unaware of the extent of the intrusion that is taking place right now under RIPA? And the introduction of this bill has, if you like, woken them up to what's going on already.
Okay. Firstly, I think me and the advocacy groups that work on behalf of privacy in particular can't really claim to speak for the public. I'm not actually sure what the public does think about this bill. It's not necessarily what journalists have reported about it or what advocacy groups talk about it, me included. And there is a distinct lack of information, and I'll maybe get to that in a moment, about what the public thinks about surveillance technology in general. It's possible that, yes, of course, the furore around this has woken the public up to surveillance technology, although I don't happen to think that what is being proposed here is in anywhere near as intrusive as some of the things that commercial companies already do on a daily basis. So I'd be rather surprised if that were the case. Instead, I think that as the reports that I've read about it have tended to say that this bill is giving unfettered access for the government to snoop on your behaviour online, which I consider to be quite inaccurate. It is regulated, it might not be perfect, there are changes that I would suggest, but if that's the way that it's being widely reported, I think that's a mischaracterisation.
Thank you very much. Lord Armstrong.
Following on that, I think my impression is that the Home Office think that this bill is as wide as it is in order to provide cover for what they need to do or want to do for a long time. And that's one of the reasons why the powers are very general. But I think I hear you say that if that's its object, it won't succeed. Is that right?
I think what I'm trying to stress is that there is a lot more in respect of regulating and putting on a legal footing the way in which intelligence and security services access information that's online that's not included in this bill. And let me give you an example. Directed surveillance, that, in other words, a police officer following an individual and collecting information about him on a public highway in the streets, does require some kind of authorization. It's quite low, but it's not a huge amount. But it is required. To do the equivalent on the internet, to collect information about any of you or about me or any suspect and to gather a profile on that person, requires no authorization whatsoever. It can just be done. Any of us could do it. And that, to me, suggests that there's a discrepancy. And it leaves agencies unsure the extent to which they can go and access these potentially very valuable sources of information legally and on a sound reputational as well as legal footing. And I believe that that is where this bill needs to go, to broaden out.
Mr. Brown.
You said earlier that you would suggest some amendments that would add to the public protection and safeguards against misuse by operatives.
Yeah.
Could you spell this out for us?
Yeah. Well, the first thing is, I think, the critical point, which is about making sure this is based on some form of public consent, and I think the process by which this bill, given its importance, has so far proceeded, has not been sufficient to do that. Clarity over certain issues to allow an open debate in the House about what's included under Schedule 1, the nature of the technology used, the international agreements for data sharing, exactly what's going to be collected. I think those things are absolutely critical to allow us to have a reasonable discussion about the various trade-offs that this bill is inevitably going to entail. I mentioned already the legal footing for social media intelligence collection that I think is not covered. Under the bill in particular, the first thing is the whole of the intelligence apparatus in respect of RIPA and other regulations is essentially built on some kind of a sliding scale, whereby the greater the degree of intrusion, the more oversight's required, the fewer agencies are able to do it. I think that in this bill, the distinction that's made between communications data, and you've heard this before, communications data and content data is obviously blurred in a way that it was not under telecommunications. The existence of a telephone call between two individuals is utterly distinct from and easy to collect differently from the nature of what's being said in that conversation. Now, traffic use data and subscriber data rather blur that boundary. I would suggest to maintain that association, that scale between degree of intrusion and the limits on who can do it and under what circumstances, you might want to look at making a distinction between use data and traffic data, for example. Now, this is technologically potentially difficult, but I see that there is a true difference in the type of websites that you visit and the browser history in use data is more of an intrusion of privacy than the existence of a communication between two people. I would suggest, for example, there is a way that you can maintain that sliding scale by making a distinction so that it's not such a clear-cut content versus CD information. That being the case, I would then recommend that judicial warrants, and again I know this is something that's often discussed, judicial warrants, particularly in the case of use data, might be applied, because I believe that one of the biggest concerns is that for all the possible arguments over whether it's more effective to have an interagency sign-off versus a judicial warrant, I think the problem is that as far as I can tell anyway, the public would be more confident with some obviously independent system of judicial oversight. And when it comes to use data in particular, I think that could be very significant.
Thank you very much. May I say, if you've got ideas on a paper on a sliding scale on differentiating use and content, it would be very helpful to have that paper, because I don't think it was in your data dialogue.
No, it wasn't.
No. I think we'd all find that very, very helpful. Can I go back to Lord Armstrong and continue?
In the data dialogue, of which you've had copies, you say that, you say on the front of it indeed, the public must be at the heart of any new settlement on data sharing. I wondered if you could explain this. It's a very general statement.
Yeah, I'll be quite brief on this. I mean, this was a paper about commercial use of personal information, so by commercial companies. And the argument was that, well, the survey that we conducted, it was a survey of 5,000 members of the public, showed an increasing concern about the ways in which personal information and behavioural data were being accessed, were being used, were being shared, for what purposes. And in general, members of the public that we surveyed for this did not see the benefits to them of sharing information. They had huge concerns about the ways in which it could be misused. And our argument was that what commercial companies need to recognise is there is a commercial dividend to taking issues about personal information seriously. That means being open about how you go about collecting people's information, how you're going to use it, what the public gets in exchange for sharing their information, how you're going to store it, and how you're going to make sure that it's looked after carefully. So this is true, of course, for public agencies as well. And I believe that all the surveys show that personal information, as we share more, and as we're going to share radically more in the next 10 years, is becoming an increasingly important consumer rights issue. And I think it's going to become a very hot political topic as well.
So this particular statement is really more about the commercial use for the information rather than the regulation of it for security purposes.
It is, although the principle applies. Huge levels of distrust or very low levels of confidence in the government to carefully, responsibly handle people's personal information for a variety of reasons and some high-profile cases that we all know about. So the principle's the same.
And do you think the draft bill we have in front of us doesn't achieve this degree of public acceptance, if that's the right word? But that's, in a sense, not a defect of the bill itself, but of the way in which it's being presented. And
I think that's partly that would be my argument. Yes.
I think you've also said that the public doesn't have a clear understanding of how personal data or information is defined, and that's really an aspect of the same problem, is it? Could you rank communications data in terms of intrusiveness and of differing safeguards for access?
That's, I think, the task of this bill, and why I argue that it might be widened out, which is that blurring distinction between personal information and aggregated behavioural data. In the minds of the public, it's not totally clear, although in our survey, what we did find was people tend to make a distinction between information that allows you to be directly identified, your name and your address and your email address, and what you could call this aggregated behavioural data. So this is the sort of shopping, the stuff about your shopping behaviour, which websites you visited, which on the whole people on average do not consider to be personal information, but consider that to be somewhere in between, between 40 and 60% in some cases, think that that sort of information is not really personal at all. And that's significant because the whole of the, as I've mentioned before, the system of regulation here must define and measure the harms involved in intruding on people's personal space in their private correspondence and their private lives under Article 8, and then manage those harms effectively. And the problem is I don't think there's a clear understanding of what the harms are and the extent to which certain types of access count as intrusive and the extent of that intrusion. And that is why I think there's a huge difficulty here. And the practical examples, I've given one with Google, but another with directed surveillance online. Another one would be entering a Facebook group. There's plenty of closed groups that people within those closed walls consider to be a private space. What is the regulation that covers when members of agents of the state enter into those and collect information? I'm not sure that RIPA really covers that adequately, and I'm not sure whether this bill covers that adequately, but to me they are much more pressing issues. So I do think there is a way of beginning to start to define different types of communication data and personal information on a scale. It's very difficult to get a true handle of that because we don't have a sense of what the public really thinks about these things yet.
If I may press this point, we have been told that they distinguish subscriber data and traffic data and user data.
Yeah.
Do you think that the public would be more concerned with one rather than the other? Do you think that the bill would be more acceptable to the public if its scope was confined to one or two of those data, but not all of them?
Well, I'll try to answer as what I think, but I can't say that I speak on behalf of a broader public consensus. As I mentioned before, I believe that, well, that's important though, yes, because it's a lot of people claim to be speaking about what we think, and it's not always clear. I believe that traffic data is less intrusive, has fewer harms entailed, fewer risks to people's privacy than use data, which is about essentially websites that you've been visiting and your browser history. I consider that to be more, I consider the latter to be more intrusive than the former, and I consider subscriber data to be more intrusive still, because that essentially is access to people's personal information. And I don't think that it's entirely accurate to lump them all in together as one data set with the same level of intrusiveness and therefore the same level of oversight and regulation required. That's my personal view.
But subscriber data, of course, at the moment, technically is supposed to be the lowest level of intrusion. But you're suggesting that, well, I presume, a mobile phone tracking where we are and reporting where we are every 5 minutes of the day, you'd consider that to be quite intrusive?
I think the potential, it's measured partly by the harms that could possibly come from agents of the state having access to that data. And that could be considered, and I consider it to be quite potentially have significant intrusive harms.
No, I'm conscious we're only at question 4 and we're at the point where we should be hearing from Lord Carlile, but we have been delayed a bit by a division. But on this point, if you're going to give us a paper on the sliding scale, do you have a view, or is there a paper you can add on the different, on your view, or the data you have on the different levels of intrusion? If you can rank in that paper, please, the things that you think least intrusive and the things you think more intrusive.
In the paper I wrote with Sir David Omond on called #Intelligence, we made some analogies between what might come under RIPA as it stands now of online surveillance. So that includes some of.
The committee would find that very helpful because we are agonising over whether we should look at revising the different scales of intrusiveness and whether we've got it right in the bill. Yeah. So, Mr. Hubbard.
Thank you, Lord Chairman. I was going to talk about the #Intelligence paper, which I think is very interesting. Congratulations on some of the ideas in it. You may or may not know that there's a master's student at King's London, David Gray, who's doing water studies, who's applied the principles here very much to this bill. I don't know if you had a chance to have a look at his master's thesis, but it makes some interesting comments on how the 6 principles you address fit with this bill. I think he's somewhat critical, but there we go. One thing I was particularly interested in is on, I don't have page numbers, page 42. You say, as the intrusiveness of the kind of SOCMENT that the social media intelligence increases, the causes for which can be legitimately used must decrease. So you say that for publicly available tweets, this is stuff which people deliberately intend to broadcast, it's a relatively long list of things, which is in fact slightly shorter than is currently in the bill. We've been talking about authorisation levels for different types of data. Would you apply a similar principle? And which of the purposes in the bill would you get rid of?
On reflection, because I've been thinking about this question a bit. On reflection, given the importance of public acceptability and some form of consent, given the often unknowable long-term potential misuse of technology to collect and analyse and use this information, I would probably go along with most of the other witnesses that you've had in arguing that it should be rather limited. Public health, for example, is a good way in which I think there's a lot of very valuable information that can be used with comms data and other types of information for public health benefits. But I think that the concerns that the public has about the potential misuse of this, quite rightly, mean that I would have a much more limited approach to it. So I would say that there's a big distinction between open source, publicly available, non-intrusive data, which is widely available to researchers and academics and commercial companies that aren't collecting this data but that are using it. And some of that is comms data too. There's no reason the government shouldn't be allowed to access that. And I don't think there should be any limits, really, on the agencies that can access that type of information, but it should be done according to quite strict research ethics. So it should take great concern over the possible harms to research participants. It should be stored in a very careful way, and that should all be set out separately. And I call this sort of open source, non-intrusive social media intelligence. For public health purposes, that would be a perfect example that you can use. The classic example, of course, is Google search terms to understand better how epidemics spread. Then beyond that, however, for the purposes of intrusive intelligence of this type, I would have it, much more limited. I wouldn't really like to go in and say exactly which agencies I would take off or for which purposes I would remove it, but I would suggest a minimalist approach rather than a maximalist one.
I think that's very helpful. If you do have any thoughts in this paper that you're sending in, I think that would be useful. 2 other things I just wanted to raise. One is in terms of your earlier comments about the amount of information that there is out there. I presume you would agree that one of the key things isn't just about regulation, it's also about teaching people on the value of data and what they can reveal. I would assume you agree with that. The other thing I just wanted to say, when you are producing this paper about sort of a hierarchy of different things, it'd be very interesting to understand whether you think that they are well-defined categories at all. Your thoughts on the overlap between content and the different categories would be very helpful, because I think what we would all be very keen to avoid is a situation where a police force or whoever it is believes a particular type of thing to be one sort when there is a strong case, it is in fact another sort, and you retrospectively go in and discover that there is a massive hole. The only way to avoid that is if you can have strict definitions and it's clear to everybody what is traffic, what is use, what is subscriber, what is content. It seems to me there's a huge overlap, but your thoughts and comments either now or in written form would be very helpful.
I'll put something together in a paper in the interest of time, although I do think it's worth mentioning that the scale of technologies, data acquisition technologies that are available now, often for free or for practically nothing, mean that there's a huge democratization in the ability of any agency to conduct huge social media monitoring. And that's really important because I think that there'll be occasions where police agencies and others will probably inadvertently breach things like RIPA without realising, because there's no clear definition of the extent to which certain information is personal or otherwise. I mean, in respect of the distinction between the three data types set out in this bill, I think you're absolutely right that there needs to be clarity on that. And what I'll try to do, and I think is really important, is to collect as much available polling data as I can about public attitudes to that, because I think that's a big part of what's missing here.
I'm sorry interrupting. I believe some of the CSPs, the telecoms companies, said, we don't understand this talk about the gap because there's a lot of information there. If they knew how to access it, it's in the public domain already, and we need to train the police and others better to find the stuff that's there. Is that a valid comment, in your view?
Yes, it is. The collection, acquisition, analysis and use of large automated social media data sets of this type, it throws open a big challenge. It throws a big challenge to agencies because it's actually very, very hard to turn that into actionable, usable intelligence. It's good information, it might provide you insight, but a lot of it's misleading. There's huge, rumours are rife, and there's problems with the collection of the data and the analysis of it that have only just been started. I think we're only just starting to understand the scale of that. I think that therefore there needs to be a huge increase in investment in making sure that social media intelligence does become part of the collection of tools that intelligence agencies have. But that's why it needs to be regulated, because we need to make sure that there is public understanding about what can be done, why, under what conditions, and by whom. So there's two sides of it. One is regulation to make it on a legal footing, which is the basis of all of this, and which is why I don't think analogies with China, Iran and Kazakhstan are very helpful at all, because we regulate the ways in which privacy is breached in a way they don't, even if they use some of the same technologies, which they do already for all types of snooping. But also there needs to be that way in which the police know what they're doing, so we don't have the risk of inadvertently breaching various regulations, which is probably easier now than ever.
Okay, Lord Foulkes.
Yes, you've been very modest about speaking for people generally in the public. I just want to ask you this. In describing your think tank, you say that the focus of your research includes citizens, juries, deliberative workshops, focus groups and ethnographic research. What's ethnographic research?
Ethnographic research is it's a particular research methodology, which is when you try to embed yourself with a community of people to understand their day-to-day interactions, their lived life as it's lived over a period of time, and understand the relationships and social dynamics within them, rather than just as a researcher peering in from above and trying to understand from a distance.
Anyway, you say in the Demos report, the Demos report, that the public tentatively agrees with regulated, restricted access within the context of social media intelligence. Given what you've already said about the difficulty in understanding the distinction, do you think, from your knowledge and experience, they would feel the same way about communications data on the assumption they understood that distinction?
Yes, I think generally speaking, my understanding is that there is broad support for regulated intelligence work, whatever that covers. What's important is that there is a proportionality and necessity test. There's due process, there's oversight and redress. The extent to which the problem here is the technicalities, which I can't confess to understand entirely, that you do need to understand in order to be able to make a decision about whether or not those tests are being applied accurately. That's why I think that one of the most important things about this bill is utter clarity over some of the technical aspects of it, and I think that's what the witnesses here, particularly from the privacy groups, have done really well to highlight. Some of the areas where more clarity is needed to allow us to understand whether or not there would be broad support for the measures that are taken in this bill. The general principle, I think, of regulated access to people's communications data and to content, I think is a fair one.
And content.
And content, well, yeah, I mean, as it exists currently. I mean, the problem with RIPA one of the problems with RIPA as it stands is a perception that it's been misused and that the necessity and proportionality tests haven't been effective enough. I think that there's a need, as I've stressed before, to be quite minimalist at this point with this type of intelligence because of all of those unknowns. The unknowns about the way the technology will change, the unknowns about the ways in which we're not sure yet about understandings of different types of privacy, and in that case, I think it's important to be quite minimalist rather than maximalist.
Lord Fox, that's when you've concluded. Mr. Brown.
Touched earlier on the need for a public debate, if only to inform our fellow citizens, and in your evidence you mention the need for a green paper. Would you say to us that we should have a green paper on the bill that is currently subject to pre-legislative scrutiny in front of us now, even if that meant delaying the bringing the bill to its formal Commons and then Lord's reading?
Probably yes, simply because what's really important about communications data now and other types of internet-based content is the extent to which it's woven into people's everyday lives. It's so important for everybody. It has a huge economic and social benefit to the nation. You know, the internet is worth billions to the economy, the value in terms of social and economic well-being, which goes back to one of the first of the three public goods that I mentioned that has to be balanced is social and economic well-being, and that could be detrimentally affected by an overreaching surveillance system. Given all of those factors, and given the fact that, as I believe, the bill has been quite inaccurately described by many of the commentators on it, I think it probably is essential because ultimately public consent is necessary for measures of this type.
Yeah, thank you.
Lord Strasbourg.
You may feel you've answered this question already to some extent, but do you have any concerns that in the area of data communications and social media there's a need to train law enforcement bodies in the use of such data if any new powers are to be effective?
Yeah, just as I mentioned before, I think that inevitably, you know, the intelligence agencies and police have spent many years developing capabilities in human intelligence, signals intelligence, and imagery intelligence and all sorts. This is quite new. It's prone to great mistakes. It's very difficult to analyse. It's very difficult to draw predictive models out of these huge data sets. You know, commercial companies are spending millions and millions of pounds training analysts and developing methods to do this really well. And I think that police agencies should be doing the same, not necessarily to the same extent as these commercial companies, but clearly the need to be able to use social media intelligence and CD intelligence as well is actually rather difficult and does require, as ever with a new form of communication, training and capabilities to analyse it accurately.
So there's a suggestion that those agencies are not currently equipped to deal with that massive volume of data?
Some of them are, but some of them probably aren't. Remember, local police constabularies are also able to tap into all of this data as well. And so GCHQ probably does have incredible analysts that do all sorts of fancy things that I have no idea about. But it could be people, it could be, you know, relatively low-ranking police officers that also have to get real-time data and make a decision about deployment very quickly on the basis of some social media intelligence. And that's actually quite difficult to do. So I think that it requires a much, given the difficulties involved and the sorts of people making decisions on the basis of this, I think, yeah, it could be done better. And you only have to read Her Majesty's Inspector of the Constabulary's report about the riots to see that actually what should have been done, or more resources should have been put in to turning information from these data sets into intelligence, to validating it, to verifying it, and then using it. And that was the problem.
But you're not suggesting that there needs to be a new level of regulation. If someone puts across his BlackBerry, let's go and riot at Tesco's tonight, the police surely in those circumstances would not need special regulations or controls before they could act on that. You're suggesting that as real-time information, they should be better equipped to exploit it.
Well, it really depends. It really depends where that data's come from, and that's the problem, because different. The problem is that on social media sites, there's a huge variety of different
some are private,
platforms. Some are more private and some are more public than others. And a very, very low level of authorization is required for some of this, but some kind of measure to reassure the public that this is being regulated in some way is probably helpful, even if it is extremely low. And as I mentioned before to Dr. Hubbard, that could also just be basic ethics about how you look at open source data.
I think we're almost Dr. Hubbard, I think your last question has been largely covered. Any other points for Mr. Bartlett? Well, thank you very much, Mr. Bartlett. That was absolutely excellent. Thank you for the paper you've already submitted, and please, we look forward to a paper on the sliding scale and your ideas on the levels of intrusiveness.
Yeah, thank you very much.
Thank you very much. I'm sorry we're running a bit late.
Thanks.
Anne. Sorry?
Division in 2 minutes.
Division in 2 minutes, right, okay. Well, welcome Lord Carlile. But we'll crack on and get the introductions done if we may. We're still in public session. Welcome very much Lord Carlile. I'm sorry you've been delayed. We've had a division and we tend to overrun on our questioning in any case. Now, just for the record, if you would state what you've been doing to keep yourself out of mischief in the last 10 years from September 2001 to 2011, which is the main reason we have you here.
From the 11th of September 2001 until February 2011, I was the independent reviewer of terrorism legislation. I remain the non-statutory independent reviewer of national security in Northern Ireland, and I also remain the chairman of the rather unhappily named committee in Northern Ireland, NICOP, which looks after close protection of judges and other senior people. So I'm still in touch with the security world, albeit not as intensively as before.
Well, thank you very much for that introduction. I think the committee are all in all of the work you've done in the last 10 years and the work you're continuing to do in that. If we could go on to the first question, for we've got a few seconds left. Mr. Ellis.
Thank you, Lord Carlile. Welcome, good afternoon. I've been interrupted twice so far when I ask a question by the division bell. It's about to happen the third time, I think. But could I just start by asking what your views are on the present law relating to the retention and acquisition of communications data, before I ask you in a moment about the draft bill and the like? And the present law may well, you may be about to say, have been accurate or adequate when first enacted. But the way things in this field move so very fluidly may not be as sufficient as they were when first given royal assent. So could you say something about your feelings about the present law?
Well, you've asked and answered the question, really. I absolutely agree with the answer that you offered.
I was at the bar for several years.
I was going to say,
I can't get out of the habit.
I was going to say a good leading question.
Order. I'm sorry. Where there's a division in the Commons. Again, we'll reconvene as soon as we're quoted in Commons terms.
My apologies, Chairman.
Thank you very much, Mr. That's kind. We're not quoted again. Order, order. We're back into public session. Lord Carlile, if you could continue to answer the question.
I hope I could pick up the thread of the question. I think what I wanted to say, and it may not be a direct answer to the question, I view this bill as an opportunity to tidy up and modernise the law in relation to communications data. It's had a very long gestation. I was asked by the last government to advise on the proposals, which are very similar to the proposals in this bill, something like 5 years ago. There's been a huge amount of work done on it. Actually, I think what this bill does is address some simple, practical questions and provide better solutions to them on the whole.
So there's been, we heard from the previous witness, Mr. Bartlett, some media which doesn't quite connect with what both Mr. Bartlett and yourself, I think, have been saying, and that the media portrayal has been, if one can generalise a little, somewhat hostile towards the bill provisions anticipated. What do you have to say about that? Do you recognise what has been suggested in some aspects of the areas of the media as accurate?
No, I don't, and I think the term Snooper's Charter is a complete traducement of this bill. I mean, I can think off the top of my head, and you will recognise this as I think you did criminal work too, didn't you?
Yes, I did.
I recognise off the top of my head, Chairman, that this is dealing with practical issues, and I can recall, straight off the top of my head, 3 criminal cases, all murder cases, in which I have been involved as a barrister, which resulted in convictions, not solely, but realistically on the basis of communications data, of exactly the type that's being sought regulation for in this bill. In one of those cases, there was difficulty in dealing with the communications data because of the non-standardization of the information sets held by the different telecommunications providers. So one was comparing, for example, O2's records, which were in a different form from BT's records, and that caused evidential difficulties in the courts. But the information that was provided was absolutely crucial.
So I take it from that you don't consider that anything about this draft bill would impede the ability of your previous organisation, your previous responsibilities, to carry out its law enforcement functions. And could you say something also about the balance, and what you anticipate would be the correct balance between the individual's right to privacy, which we all accept is an important right, but the need to access communications data for proper law enforcement activities?
Well, nothing in the proposal in this bill would authorise the interception of the content of a communication. If the content of a communication is to be intercepted, that's a matter of special application, which exists in another form.
And that requires the Home Secretary, doesn't it?
It does, yes. And as I understand it, the oversight powers for that kind of interception are being strengthened. Also, the very small proportion of RIPA requests made by, for example, local authorities, which are often trotted out as the worst possible example of RIPA requesters, is now being regulated by limiting access to those applications that are approved by a magistrate. So I don't think there's any weakening of privacy in this bill. What is absolutely essential for the proper detection of very serious crime is that the police should be able, for example, to know who was telephoning whom and for how long, at what time. It's used every single day in the courts up and down the land, and prosecutions brought by the CPS in very serious cases would be brought to their knees if this was not possible. What this does is standardise the data sets and ensure that all the companies concerned know what they have to do.
And do you agree with Mr. Bartlett, therefore, previous witness, that there is a gap in the law at the moment which actually would be filled by provisions such as those anticipated in this draft bill, which actually would serve to regulate the law enforcement agencies better than they are now, and therefore protect the individual's right to privacy, because it would be codified in a more collective fashion.
Yes, and a very simple example is that some of the telecommunications companies keep this data for 2 years. This bill requires them to keep this data for 1 year, for a minimum of 1 year. They may keep it for longer, they may not, though I apprehend that they're likely to standardise and keep it for 1 year and then dispose of it, delete it at that stage.
So finally from me, the present law, it's said, is insufficient in two particular respects I want to ask you about. The first is that it doesn't cover providers based overseas. And the other is that it doesn't require providers to retain or even generate communications data that they don't already need, that they don't have any business need for. So, as you alluded to yourself, Lord Carlile, in the criminal courts on a regular basis, there is the use of such data, because that has been available because providers have had to collate that information for their own bill charging in many cases. But now, with advances in communications, not all of this data is necessarily collated for bill purposes, and therefore the proposed provisions in this bill would require that. Do you recognise those two as areas, as holes in the provisions as they currently stand?
I do. I think the question of business need must be considered, but actually there is a public need for this information to be retained for a certain period, and preferably in a standard form. I do have some views about the scrutiny aspect of this. I don't think the bill quite goes as far as it could in dealing with scrutiny. On overseas providers, this of course is a difficult jurisdictional question and requires, dare I say it, cooperation, particularly on a European front, to ensure that information of this kind can properly be shared. We do run into problems in the courts over the different standards about communications data and intercept. For example, intercept is admissible in Dutch courts, it's not admissible in English courts. I have been in a case, therefore, in which Dutch intercept was admitted in a Crown Court in Nottingham. Now, that sort of anomaly needs to be ironed out on an international basis, irrespective of whether it's intercept or not.
But you would support this bill?
Yes, I do.
Thank you, Lord Chairman.
Lord Salisbury, you had a follow-up on this?
You've spoken passionately about the benefits of CD in law enforcement, and I don't think anybody is proposing any reduction in the use of communications data. How do you feel about content being part of the data that's available to law enforcement?
I am wholly opposed to content being available routinely, and this bill does not provide for content to be made available. There are cases, obviously, in which content may be extremely important, and there may be good reasons for making a proper application in due form to obtain it. It does happen, again, all the time, though to a much lesser extent than accessing communications data.
That being the case, are you aware that the draft bill takes us into technology areas where it becomes increasingly difficult to separate data from content, and in particular, but not exclusively, in where encryption is used? When encrypted information is decrypted, it's very difficult for those who are doing it to be able to anticipate where they're going to find content and where they're going to find data. So does that give you any concern at all?
I was advised when I was independent reviewer of terrorism legislation that proposals of this kind would not result in content being revealed. And I am not a technological expert. I think it's a matter for the committee to assess whatever evidence it receives. I do think that it's important that if content becomes revealable, it should be filtered out and not seen by the authorities without the correct authorization. This is akin to the filtering out of legal professional privilege information in a criminal investigation, which is now done routinely by people like Disclosure Council or employees of the CPS. It can certainly be achieved. It's just a question of having the right mechanism in place to deal with it. I mean, typically, if somebody is arrested in a fraud case and computers are taken with millions of documents on them, then the question of legal professional privilege is dealt with separately before the inquiry team see any of the evidence. And I believe the same could be done rather more easily, actually, with this type of data.
Yeah, with the older technologies, with just straightforward telephones, it's very simple to separate content and data. But in the environment that this bill is moving us into, it's becoming increasingly difficult in some cases to do that.
Oh, well, I accept that if that's the evidence the committee has heard. Somebody will have to solve that problem. It's not going to be me.
I think before we move to Lord Fox, if I could pursue this point, I think we all agree that who phoned who for how long, and the telephone numbers and the subscriber data is absolutely essential. Some of the evidence we're hearing is, for example, now we move on to the internet. If I am logging on to Alcoholics Anonymous, that page in itself is in some ways content. It is showing that I may have a particular interest in logging on to Alcoholics Anonymous, and therefore it is revealing in some extent the content. Do you accept that might, if that is the case, that there is an element of content there which would then have to be strictly regulated?
Well, it's a very fine distinction, I think, if I may say so. If I can take one of the cases I was in, the cell site analysis showed that my client was communicating with the man who she had hired to murder her husband. So her number was her number, the client who was conspiring to murder, and the recipient number was his number, the man who committed the murder. So one knows through other material who they are. If somebody is logging on to a terrorist website which is teaching them, for example, how to make a bomb, what's the difference? It's a very analogous process. So I can't see any reason myself why the originator and the recipient of a log-on should not be disclosed in the same way. Obviously, the scrutiny process is extremely important to ensure that it's not abused. And I have some reservations about the extent of the scrutiny process in this bill.
We shall come to those in a few moments. We will not miss those out. Lord Fox.
My question's been covered, but if I may, Chair, ask a different question, which is this. CSPs, if this bill becomes law, are going to have to retain information which is not in their commercial interest to retain. From your experience, both as an independent reviewer and as a barrister, do you think this additional information is likely to be useful?
Probably not in most cases. In the occasional case, additional information will be useful. But it is the raw data of the kind that we've been discussing, which the Chairman mentioned just now, which is of real value to the authorities, the communications data, which is what this bill is all about.
Lord Armstrong.
I think one of the points I was going to make about content have been covered in the previous discussion.
Lord Strasbourg, number 6.
The Home Secretary and the Justice Secretary have stated that they estimate that 25% of the communications data required by the police and agencies can no longer be acquired. Is this your experience?
I have no basis for confirming or denying that. I don't know. I've not done that statistical exercise. I accept what they say.
You do?
Well, if they say it, I accept it. I presume their statistics are broadly correct. I've no reason to doubt what they say.
Okay. Are you able to share with us any instance where this inability to access data has impacted on the conduct of an investigation or the prosecution of a case?
Well, if there is data that's not available, plainly it's going to impact upon an investigation. But if 75% of the data is available, then unless those who are committing crime have a very peculiar knowledge of what is unavailable, there's a 75% prospect of the necessary data being available logically. And you know, my experience, such as it is, over the last 42 years of criminals of all shapes and sizes, is that they're nothing like as clever as you would imagine. You'd be surprised how many very serious criminals make phone calls on lines that are listened to or send text messages that can be tracked and retain them in their telephones so that when they're arrested, all the police have to do is switch the phone on and start scrolling.
So you're not aware of any particular instances?
I'm not aware of any particular instances. I'm sure there will be instances where people have used a provider whose system cannot be traced in the same way. But you know, even if 25% of information cannot be traced in that way, if the inference is that we shouldn't bother with the other 75%, I'd reject that out of hand as being illogical.
I don't think that is the inference. No. The Minister for Universities and Science has told us that the number of communication service providers subject to data retention obligations is and will remain a fraction of the providers in the UK. Does this surprise you?
Well, it does surprise me because under Clause 1 of this bill, and indeed under this bill generally, my understanding was that the requirements to retain the data could be extended to other providers. Am I wrong about that? I don't think so. No, I'm right about that. You know, so you know, it's the duty of the Home Secretary or whoever is the responsible minister to find out who the relevant providers are and add them to the list. I think it's done by order, isn't it, under the bill, so there can be a prayer against if anyone thinks it appropriate.
What are the categories of additional data?
Of
additional data that you would wish to be collected that providers do not currently hold for their own business purposes, but would be necessary for investigatory purposes?
I don't think there is any or much, at least. I think that the police get by very well with the availability of the sort of information that is retained at the moment, save that it would be helpful if it were retained, as I suggested earlier, in a reasonably standard form. I mean, inevitably companies develop their own data sets for entirely understandable reasons, but it would be useful if they were willing to get together and ensure that standard types of information are provided. Sometimes seconds matter in very serious criminal cases, and the way in which times are recorded may not be entirely standard. So that's a problem that needs sorting out. And again, I've been in one case where that issue arose, at least for discussion.
Lord Carlile, could I ask about that? If we were to say that, if we were to suggest that these powers should be confined to data which the companies hold for their own business purposes, you think that would go a long way to meeting the meeting the requirement? I mean, there would be some data which they would not get, but if we were to say that it would be a good idea to confine the requirement to hold and store to those categories of data which they in any case hold for business purposes, but require them to hold those data for longer than 3 months or 6 months, say 12 months, which is what is in the bill, that would get us a good long way towards achieving the purposes of the bill and possibly help to calm public concern about privacy.
I think it would defeat the purposes of the bill, if I may say so. For this reason, businesses will determine for themselves what they require to retain for business purposes. billing processes in mobile telephony are becoming ever more sophisticated day by day. Companies wish to retain less and less because retaining things costs money and involves people working, and usually quite well-paid people working. I think, therefore, it's the responsibility of the government to decide what set of data needs to be retained, the kind we've been discussing earlier, and then ensure that the companies retain it. As to the second part of your question, Lord Armstrong, I'm not optimistic about calming, not public opinion, but the opinion of people who have been prepared to talk stridently against this bill, because by and large it's extremely ill-informed and inaccurate. And I think it's only an optimist who would believe that there is that a particular group of people could be persuaded that actually this bill was relatively harmless and positively helpful to the public interest. I think Parliament just has to be brave about this, bearing in mind that successive governments have seen the necessity of introducing this legislation. It's not really a party political issue at all. It shouldn't be.
Thank you.
Lord Carlile, can I go back and try and press a little bit further on a question Lord Strasberg had asked, where he said that the Minister for Education, or for Universities and Science, has said the data retention obligations will only impact on a fraction of the providers in the UK, and you answered it by saying, well, Clause 1 allows it to catch everybody. And that's part of the problem we've been wrestling with. I think some of the communications providers, the telecoms operators, said that we don't know what the government wants. Clause 1 is massive, it could involve everything under the sun, but privately the Home Office say, oh, don't worry, it's going to be a very light touch, it's only going to be a few people caught. What I'm trying to get at is, in the advice you've been giving successive governments and your involvement, have you any indication you can share with us as to what the real target is, how extensive the orders might be, and whether it will be more than just the big 6 telecoms operators caught?
The first piece of advice that I gave, maybe 12 times a year to successive governments is you've got to be much better at narrative. The narrative over these proposals has, in my view, been inadequate, and there's been a much stronger counter-narrative. So I think the government could have told both governments, successive governments, could have told a much stronger story. I think that the government and the industry need to be seen to cooperate, and it should be made clear that what is aimed at here, basically, is ensuring that the necessary data from all equivalent providers, whether they're large providers or small providers, is retained for a period of 12 months so that it can be interrogated by the investigating authorities where it's appropriate and proportionate. That really is the simple message that has to come out. I believe that any government would be, and you as a former chief whip would know how defensive large political parties, at least, are. I think that
we're all in this together.
Yes, I think that it's entirely understandable that the government, for the time being, has no appetite for suddenly opening a new warehouse full of data, because that brings down criticism like a ton of bricks. So I think we can reasonably expect any government, whether there's a change or not, to be cautious about the number of orders it lays extending these provisions. I think that's a realistic view.
Finally, for me, you've talked about the government and the industry need to cooperate better and be seen to cooperate better. Would it surprise you if I told you that we've had evidence from many of the big telecoms companies saying that the only discussions they had with the Home Office were a few days before the bill was published or the day after, and some of them said the first discussions they had with the Home Office were after we summoned them to give evidence to us in this committee?
It wouldn't surprise me in the least, but it should surprise me.
Yeah, thank you very much. On to scrutiny, Lord Fox.
Yes. See if you can compare, if you would, the role that you performed as independent reviewer of terrorism, looking at, amongst other things, control orders and their successors, and the role of the Interception of Communications Commissioner, who has a different role in relation to these communications. Do you think his powers, or her powers, because he's about to be succeeded, are sufficient or could be improved or supplemented?
I think the powers are sufficient. I think there's a difference of perception. The independent reviewer of terrorism legislation, whether myself or my extremely good successor David Anderson, carry out a very public role. And I think the public nature of that role is reassuring to some and, to use a neutral term, satisfying to others. If I can just finish the sentence.
Please do.
Satisfying to others, because at least they've got something to criticise. I think the lack of public face of Sir Paul Kennedy's role, and he's a friend and I have huge respect for him, is a difficulty, and that's why I would like to see a slightly different form of scrutiny in this bill.
Lord Carlile, are you able to give us another 20 minutes?
Yeah.
In that case, we will suspend for the vote in the Commons, and please, Commons colleagues, come back as soon as you can, and then we'll crack on, as soon as we're quoted. Okay, right. All right. How many are we losing? Will there be 2 Commons colleagues back at all?
3. Quorum is 3.
3. Oh, so it's 3. Right. That's 2. Nick Brown. No, that's only 2. Yeah. Blast. Right. Okay. If we're going to be in quoted, we cannot continue. I'm sorry about that. Because we will, by hook or by crook, we want to get a little bit more from you, which we will not be able to. We will not be able to take today. Could I suggest we will try, Lord Carlile, if we may, to find a 15-minute slot at your convenience, if we can, just to get there's a little bit more scrutiny I think we'd like. Or if not, perhaps we can send you questions and you can give us written answers. By that, written answers will
send me questions, I'll reply to them.
That would be very helpful. In that case, the committee is suspended. We will have a little bit of private wash-up for those who come back. Okay, thank you very much.
Committee Room 2, Sound.